But at the end of the day, you can use all the fancy legal words you want. What this is about is discrimination is discrimination, and all this says is whether it's intended or it's at the actual effect, that is a violation. Thank you, Madam Speaker.
Discrimination is discrimination. Even if it's in effect, even if it manifests as disparate impact. Discrimination, a synonym for that would be choice. When one discriminates, they choose between this and not that. It requires an actor, it requires intention. This whole idea of disparate impact is a fallacious idea that is fundamentally flawed. There's a widely understood concept in statistics that correlation is not causation. But suddenly when we port that over into the legislative realm, any demonstrable correlation becomes proof in a court of law of causation, and the only possible cause is discrimination, regardless of intent, regardless of the choice by an actor. Representative Niska is absolutely correct. The inclusion of these two words, or effect, in the underlying amendment is going to break the jurisprudence of the state of Minnesota. Our state will not be able to function. Anyone, anywhere, who can point to any correlation, statistical correlation, will be able to bring the claim in a court of law that that is caused by discrimination. And regardless of the merits of the case, they're still going to have to fight it. They're still going to have to pay for lawyers. It's going to become disruptive. We see what the culture of litigation does to our economy, what it does to our institutions. Anybody who's worked for any employer has had some kind of encounter, some sort of coaching along the lines of, we better not do this, not because it's wrong inherently, not because it's inherently discriminatory, but because we can't afford to defend the claim. This is going to put that on steroids, especially in the context where you guys just voted down one of the previous amendments that clarified what we mean by the state. You don't want to say that the state doesn't include private actors, that it doesn't include people who receive state funding. You want to leave that up to case law. Well, there's going to be a bunch more case law, tons more, if this gets ratified, because you're going to be exposing literally everyone to claims of discrimination based upon effect, based upon disparate impact, at the drop of a hat, limited only by their capacity to fund lawyers. This is deeply reckless and irresponsible. Just in terms of, take all of the moral arguments out of it. Just in terms of good governance, you are breaking the jurisprudence of the state of Minnesota. If this gets ratified, no one with any common sense whatsoever would ever choose to plant their shingle within these state lines. Why? Why would you do it? You can go literally anywhere else. There's 49 other options within the United States of America where you're not going to have to worry about some nebulous claim of disparate impact, where you're not going to have to worry about being discriminated against in effect, regardless of your intent. We're going to put this in our Constitution. That is like setting up a sign at the border that says, "Don't do business here." And that's exactly what's going to happen if you don't pass the Niska Amendment, and then this goes on to be ratified. Thank you, Madam Speaker.